Welcome everyone to today's webinar on the future of virtual hearings. We're going to wait just a moment before we begin to give folks a chance to join the webinar. So thank you for your patience, and we're glad to have you with us today. Okay, and for those who are joining, welcome. Glad to have you with us today for this webinar on the future of virtual hearings. We're going to give just a moment for the last few folks to join the webinar, and it looks like we've got a good number, and so we'll get started. All right. So again, welcome. My name is Keith Greenberg. I'm a labor arbitrator based in North Bethesda, Maryland, and I'm a member of the National Academy of Arbitrators, one of the co-sponsors for today's program. And among other things, I serve as the Academy's technology coordinator. I'm pleased to be your moderator for today. So to state the obvious, virtual labor arbitration hearings and labor board hearings have become a fact of life for many of us over the last year and a half, as we've all adapted our work and practices to the demands of the pandemic. Our goal today, though, is to look just over the horizon at how virtual hearings may stick around once the health concerns that have driven the recent use of video conferencing for virtual hearings become less pressing. So we'll spend some time today looking back at the experiences of neutrals and advocates in virtual hearings during the pandemic, discussing what has worked well and served the parties in the process well and what has not, assessing how virtual hearings may be used in the near term, and also looking at longer term developments that may come up from the increased acceptability of virtual hearings after our pandemic experience. We welcome your questions, and there's a Q&A button on your toolbar at the bottom of your Zoom window. Feel free to submit a question throughout. We'll take those occasionally during the presentation, and otherwise we'll try and get to some of those at the end of the session today. As we get started, I want to take a moment to introduce the three organizations that have collaborated and co-sponsored today's program. First is the Association of Labor Relations Agencies, or ALRA. ALRA is an association of impartial government agencies in the United States and Canada, responsible for administering labor management relations laws or services. ALRA promotes cooperation among agencies, high professional standards, public interest in labor relations, improved employer-employee relationships, the peaceful resolution of employment and labor disputes, and the exchange of information regarding the administration and improvement of agency services, including but not limited to mediation, conciliation, fact-finding, arbitration, or adjudication. Next is the National Academy of Arbitrators, which was founded in 1947 as a not-for-profit honorary and professional organization of arbitrators in the United States and Canada. Members are chosen by involved parties to hear and decide thousands of labor and employment arbitration cases each year in private industry, the public sector, and nonprofits in both countries. Admission standards are rigorous, in keeping with the goal of establishing and fostering the highest standards of integrity and competence. Last but certainly not least, the State and Local Government Bargaining Committee of the Labor and Employment Law Section of the American Bar Association. This committee's scope involves all significant public sector labor relations issues, and its members publish an annual report each year focusing on case law and bargaining developments in the areas of grievance arbitration, constitutional issues, bargaining unit determination, the resolution of interest disputes, duty of fair representation, and other bargaining and process issues. That committee holds an annual midwinter meeting, and the 2022 meeting is scheduled for January 27th to 29th. We all thank the ABA, particularly Section Director Brad Hoffman and Associate Director Rose Ashford, for their help in hosting and running the logistics for this program. So let me introduce our panelists for today. First, Jeannie Charles. Jeannie resides in Florida with a multi-state ADR practice in the Fort Lauderdale and Chicago areas involving workplace and commercial disputes. She earned her JD degree from DePaul University College of Law in Chicago. She serves as a labor and employment arbitrator on various private and public sector panels, including those involving professional sports. In addition to serving as chair of the National Academy of Arbitrators Video Conferencing Task Force, Jeannie serves on the Board of Governors for the Academy and is also a fellow with the College of Labor and Employment Lawyers. Jeannie serves as an adjunct faculty member with the Pennsylvania State University School of Labor and Employment Relations and with the University of Arizona School of Law. Prior to becoming an arbitrator, Jeannie practiced as staff counsel for a federal sector labor union in Chicago and in private practice. Next, Kimkia Harris. Kimkia is an attorney with the Illinois FOP Labor Council, and she's been there since June of 2011. She has a BA in political science from Fisk University and a law degree from Washington and Lee University School of Law. Before joining the Labor Council, she was the coordinator of labor relations for Memphis City Schools, an assistant city attorney for the city of Memphis, and an assistant district attorney for Shelby County. Next, we have Jason Patterson. Jason is an attorney at Franzik PC, a mid-sized labor and employment and education law firm in Chicago. Jason advises public and private sector employers on all aspects of employment law, including workplace discrimination, health and safety, wage and hour, whistleblowing, employee handbooks, termination, and disciplinary action. Jason dedicates a significant amount of his practice to counseling employers in traditional labor matters, including collective bargaining, union organizing campaigns, grievance arbitration, and matters before federal and state labor boards. Before joining Franzik, Jason was a trial attorney at the U.S. Department of Labor in the Office of the Solicitor, and was also a field attorney with the NLRB. Last but certainly not least, Monu Singh, who is the Deputy Chair of Dispute Resolution at the New York City Office of Collective Bargaining. In this role, she oversees dispute resolution procedures relating to grievance arbitration and contract negotiations for New York City's municipal unions and agencies. She also administers the agency's arbitration process and serves as an arbitrator and mediator. Prior to joining OCB, she was the Director of Labor Relations at MTA Long Island Railroad. Monu holds a BA with honors from Villanova University and is a graduate of the Rutgers School of Law in Newark. So we have a tremendous panel with us today, and I'm looking forward to our discussion as we look back and look ahead on the issue of virtual hearings. So in our preparations, we had some discussion as a panel about what our practices look like right now. And so let me start off by posing this question. It's August 2021. And so briefly, let's talk a bit about how your hearings have changed since March of 2020, what your hearings or your organization's hearings look like now, and how you're feeling about virtual hearings after doing them for quite a while. So Jason, let me start with you.
Sure. Well, first, it's great to be here with such an esteemed panel. Thanks, Keith, for putting it together. I think this is going to be worthwhile for all of us to kind of learn each other's perspective. So first, to the question, I think for me, a little bit of context is useful here. So, prior to or pre-pandemic, I think with the exception of a couple of practices where it was routine to have phone hearings or remote hearings, I think there was sort of a negative stigma with the idea of, hey, can we bring this witness in remotely for this purpose? And so, when we were forced to face this head on and go to exclusively remote, I think all parties came with their kind of preconceived notions of what a remote hearing was, or what it was to take non-live testimony. But I'm a strong believer in crisis sort of being a driver for innovation, and I think at the beginning we all sort of fumbled through those first couple of hearings if we weren't used to it. I call them, there were a lot of let me see moments. Let me see if I can share my screen here, or let me see if I can put you guys in a breakout room. But over the year, just in this a little bit over a year, I've seen improvement from all parties, from the attorneys to our neutrals, to our witnesses. And I think that's because as a whole, our whole world has changed. And so even outside of this context of hearings, everyone has become more adept to just being remote in general. And so I've seen this progress. and I've just seen the hearings get better as we've gone. Now there's definitely issues. There's technology issues, and I'm sure we'll get into a lot of that as we kind of parse out some of these things. But as a whole, I've just seen the quality improve with the hearings. And so, and I think we were just discussing before we started here, we're sort of in this sort of gray area now where some are starting to go back to in person, but we're still doing a lot of remote hearings. So I just expect things to sort of stay that way, and for the process to continue to become better as we just learn how to navigate.
Thanks, Jason. And just to understand a bit better, in your practice, are you seeing mostly virtual hearings, mostly in person, or a mix?
Right now, definitely, I'd say within the past 6 months, it's been remote. We started to get a few in-person arbitrations and hearings on the books, but slowly things are starting to kind of turn again. And we're starting to kind of reschedule again, or either, I have a couple of matters that we'd like to be in person for various reasons, and we're just kind of, the parties have agreed to push them out. Others have just been converted to stay remote. So I think it's going to continue to be fluid, as we know. We can't predict what's next right now.
That makes sense. Thanks, Jason. Kim-Kia, how about for you?
Thank you, Keith. I too want to thank everybody for the opportunity. I look forward to having this discussion and to discuss how the world has changed. And as we know, March 2020, the bottom just fell out of the world, and we didn't know how to function. So I'd say at that time frame, our practice was pretty much, what do? We are always pushing things off for the future and hoping that it would change. And with each news story, we realized it wasn't going to change, and we had to learn how to adapt. So I would say that what happened from our practice perspective is that there was a lot of tug of war, I think, between the parties on how you were going to handle your practice for a while. Were you going to move it further out with the hope that, you could have an in-person hearing? There were a lot of fights, I think, about how to do virtual and should we do virtual. My perspective as a union attorney is that, in my experience, and I know Jason, I don't agree with that because he's on management side, but from my experience, there were a lot of management attorneys, offices that did not want to go virtual. So we would end up having an argument or disagreement on how to proceed and whether or not we should proceed, whether or not the case should continue to be delayed. And of course, depending on what the interests are, especially if we're dealing with something as a termination case, that becomes a real issue for us as a union because we have someone who's unemployed who is not being compensated. So there were a lot of resolutions and a lot of things that we had to take to the arbitrator to say, could you resolve if the two parties don't agree on how this matter should proceed or not? And I have found that arbitrators pretty much split on how they were going to decide it. Some were more decisive. Some would only agree if the parties agreed. And then there were some, I believe, were put together such conditions that made it almost impossible to proceed in person. So my practice in the last year and a half, I would say, has all been virtual. I think that we've gotten very comfortable with virtual. No, I've been very comfortable. And whenever I suggest that concept, it seems like all parties, including the arbitrator, would jump at the option. So I see it definitely being something that we will continue in the future. Because we feel like, and on my perspective, I believe it's been productive. I believe it allows me to be more productive. I see that some arbitrators feel like it also makes them more productive because everyone is in a more convenient location. The ability to get the hearings done effectively, we've gotten better at it. We know how to move through the process. So I totally think that this is something that's going to be part of our future.
Thanks, Kim-Kia. Monu, let me turn to you next, and you're in a different spot than the rest of us as deputy director at or deputy chair at a labor relations agency and one overseeing an arbitration process. What have you seen from the parties and arbitrators that you work with?
Yeah, so I'd like to just echo Jason and Kim-Kia's comments, and thank you, Keith, for organizing this, and also for all of the organizations that have put this together. I think it's just a really timely discussion. So just to give a little bit of context, at OCB, we have sort of two broad categories of hearings. We have trial examiners who are similar to ALJs, who hear like improper practice hearings, representation proceedings, et cetera. And then we also have arbitrations that are conducted with arbitrators, private arbitrators who are from our register of neutrals. And so I administer that process as well. And so prior to March of 2020, all of our hearings were in person. And in fact, our office, like we hosted them, most of them were in our office. We have hearing rooms where we would host these hearings. At the most, there might be a witness or two that might testify telephonically in a case, but that was also very, very rare. Once, March 2020 came around and everybody had to kind of pivot to this new model, I think that we as an agency made a big push to encourage the parties who certainly were reluctant and apprehensive initially because they weren't used to this model. For 50 plus years, they had only been conducting in-person hearings, to try to get them to embrace this process, because part of our responsibility too is to do what we can to maintain the integrity of the process, keep the cases moving forward, ensure that decisions are being issued, et cetera. And so what we didn't want to happen is for there to be delay, and next thing you know, you have cases that are potentially 3 or 4 years old with stale evidence being heard, right? And also we have no idea what the future might hold. So we're now at a point, and over the past year and whatever it is, year and a half or so, where the vast majority of our cases are virtual. I would say that I could probably count on one hand the number of in-person hearings that we've had. And 2 of my fingers would represent cases that have been heard in just the past couple weeks. So it's really not something that we've seen, that there's been a big push to keep cases in an in-person setting. So, personally, I think that virtual hearings are fantastic. And I say this as, someone who is, I'm not like your great grandma, but I'm also not like the most tech savvy person either, right? So I think that there is a lot to be ascertained when you're in the same room with people, especially I also do mediation. So it helps me to be in the same room as people, to kind of feel their energy and their vibe, and it helps me kind of manage the process. So I say that as someone who works in that way, that I think virtual hearings are great. I think that they are effective. I think that they are efficient. I think it cuts out a lot of like the delay and time that gets spent in sort of other things when we're in person. So I think it's a wonderful way of conducting business, and certainly as our agency, this is going to be a continued offering that we have.
Thank you, Monu. And Jeannie, let me turn to you next.
Thank you, Keith. And thank you all for participating in this panel. I'm pleased to be here and pleased to continue the conversation about virtual hearings. So with regard to what my current docket looks like, everything has stayed virtual since the pandemic started. I've had one in-person hearing, which was late last month, and it actually did not go forward because once I arrived, the parties advised that they were going to hold the case in abeyance. So that that was a trip to hear that information, whereas if it had been scheduled virtually, obviously there would have been not the waste of time that had occurred in that situation. However, because we thought things were getting better, I had started scheduling some hearings to be in person. Now, let me say this, prior to the pandemic, I was conducting some hearings virtually anyway, which is how I think partially how I got landed into the role of chair for the VTF for the Academy. So I had some familiarity with how to do those types of hearings. And so with regard to the parties who I held virtual hearings with prior to the pandemic, we've continued to schedule them that way. Others, even when, I may get a case that's assigned, through an FMCS roster or AAA roster, my ask as we're scheduling is, is this a case that is suitable for a remote hearing? And when I say that, I do offer, various configurations, because I think that when you say virtual or remote, it could mean with everyone being in different places, or, a number of different configurations. Some being, counsel being with their client, witnesses being remote, the arbitrator just being remote. So I do tend to have those discussions. For the fall, I have, I believe, 2 hearings that are set for in person, but um, as our public health situation gets to be more dire, we may be having some conversations about whether or not to proceed that way, or whether there should be a delay. So that's what I've been experiencing. What I've been very delighted to see over the course of this last year is that, and I would echo what the advocates have said here, is that everyone, they adapted very quickly. I was quite pleased to see that, although there was some hesitancy early on, but it's become clear that everyone is using Zoom. It's probably like the fax machine was early on. It was new technology then, and people had to figure it out. But once they figured it out, they wouldn't stop using it. It became, the norm. So I think that what we've been experiencing is that there will be sustainability in the virtual hearings going forward.
Thanks, Jeannie. And let me stay with you as we pivot a little bit to go beyond sort of our anecdotal experiences to some research that's been conducted, some data that's been collected on experiences with virtual hearings during the pandemic. So Jeannie,
Absolutely.
let me stick with you there, and interested to hear what some organizations have come up with.
Okay, let me just share my screen here. So hopefully everyone will be seeing the slides shortly. Are we good to go? Okay. So I just put together a few slides with respect to a couple surveys that were conducted. These slides are highlights of recent reports issued by the National Academy of Arbitrators and the National Academy of Distinguished Neutrals, whose members are providers of arbitration and mediation services. So the participants were surveyed to assess their experiences with the use of virtual hearings and mediations during the pandemic. Additionally, participants were surveyed on the anticipated use of virtual platforms for the future. So I'm going to just jump right in and give highlights of each report as a barometer of those experiences. So with the National Academy of Distinguished Neutrals, that is they have chapters that across 42 different states, and they conducted a survey of their members in June of this year. And you should be able to actually get the full report through the materials that are going to be available in this session. But in their report, They looked at the information from a variety of angles. This slide shows from a regional breakdown the preference for favoring online platforms by default. And as you can see, it's most favored in the Western region, followed closely by the Southwest. Then the Northeast, Southeast, and lastly, the Midwest found it favorable as a default practice. So it'd be interesting to find out what's, the drivers behind those numbers. Perhaps it's the, commuting and things of that nature that drives the interest in using the virtual platform as their default. Of note is that overall, most respondents conveyed remaining mostly online and in person only when the parties insist, as opposed to being mostly in person and online when the parties insist. So this next slide asks the question, looking back over the last year, what did you find to be positive? And this survey was from the perspective of the neutrals, and again, mostly mediators, getting feedback from the council that they worked with. So there was a obviously decreased cost and efficiency was overwhelmingly the most popular justification for the use of virtual platforms. As you can see, council found the virtual environment to be just as effective as in-person meetings. And that was the next highest category, with better engagement, better attendance, and faster resolution as additional positive feedback. Next, they asked, what did council not like about the virtual setting? And technical issues were by far the highest, well, strike that. Lack of personal interaction was by far the highest response, which is something that we have heard. I think that's been a pretty steady response to. I don't think it's just the virtual hearing. I think that that's just life right now, because we're all so remote all the time that I think that that's an outcry of wanting to, be in the presence of other people. But that was, in fact, the number one response, with technical issues being the next highest objection, and less engagement, followed by less engagement. But note, however, that we just saw on the previous slide that there was twice as many respondents who thought that there was more engagement as a result of the virtual platform. And next, the National Academy conducted a year in review report that was conducted by the Video Conferencing Task Force, with a couple of the members there being the lead on that, which was Sylvia Skradek and Raphael Haley. They did a wonderful job of assessing the responses of attendees at one of the office hour sessions back in April of this year. And again, those materials are provided, and the full report is also available on the Academy's website. Their report showed that what respondents really liked about the virtual setting was that, again, the decreased need for travel and the costs associated with that. Next, they found that it was easier scheduling. Again, you don't have to look for dates for the outbound trip as well as the inbound trip in order to set a hearing date. Easier to concentrate for long periods of time, which I thought that was an interesting one. And easier to conduct the hearing, some of their respondents found. What they didn't like, technical interruptions, which no surprise. And I think that really we're getting better and probably more patient with the technical interruptions aspect of it. I mean, clearly you aren't able to necessarily control if someone has, bad broadband or something like that. But I have seen more creativity with witnesses being co-located with counsel, and so that they're in an office environment where they can have access to better technology. So let's continue on with the results of the year in review report. A significant number found it more difficult to control witnesses. And then there's the dreaded credibility assessment obstacle, which I'm sure we'll talk about in more detail. And the final two objections were difficulty controlling the hearing and contentious parties, which may be something that occurs in person as well. So overall, the report revealed very high levels of satisfaction. As you can see, over 58% were very satisfied with virtual experience, and no one was very dissatisfied. So I believe the takeaways from this and both reports is that the ADR community, that being neutrals and advocates, effectively adapted to the virtual process. But as we move forward, clear protocols should be put in place to minimize distractions and refine technical skills, which I'm sure will come with practice. And in all of these presentations, I've said practice, practice, practice. One thing that I will note that we saw more so in the height of the pandemic that I'm not seeing as much currently is the need for the pre-hearing conference to go through the technology. So I think that's an indicator that people are more comfortable and more skilled and adept at using these platforms. So I think one value added development that has come from using online platforms is that both the parties and neutrals were able to expand their reach and access to services and clients beyond their immediate areas. And the individual reports make reference to that. Moving past the pandemic, in my view, at the time of case scheduling, the option of a virtual proceeding should be explored. Just using sort of a balancing test of whether or not it makes sense. And the Academy's report makes reference to some factors to consider in that regard, which include the type of dispute, convenience, and scheduling efficiencies and cost. And that is the end of that report. Thank you.
Thanks, Jeannie. And for our audience, the National Academy of Arbitrators Year in Review Report and the National Academy of Distinguished Neutral Survey are both in the chat for you to download. My understanding is that we'll have those available when the recording of the session is posted by the ABA, but in the meantime, you can access those there. And I'll put Jeannie's slides in there for you all as well. So most of the survey respondents in both reports were neutrals, arbitrators or perhaps mediators for the National Academy of Distinguished Neutral Survey. So let's turn to our advocates, to our Labor Board Deputy Chair, and get a sense of what drill down in some of the issues that you've encountered with virtual hearings over the last year and a half. So to start off, for Kimkia and Jason, how did virtual hearings affect arbitrator selection? Jeannie mentioned that arbitrators at least were expanding their geographical reach, and that may be one of the things you've seen, but Kimkia, let me start with you. How is arbitrator selection affected?
I think it's very important that an arbitrator be familiar and comfortable with the process of going remote. So, as a union advocate, I would look for an arbitrator that would have that option available and also was comfortable being the one that was in charge of that particular hearing. There have been some arbitrators that rely a lot on the court reporter. I don't have a problem with that per se, but there was one recently that seemed, in a case that I might not have used a court reporter in, seemed very insistent that we have a court reporter that handled the hearing. So that to me would become a concern because that is an extra cost. That might be a case that I don't think would, really justify that type of cost. So for an arbitrator, when I'm trying to select someone to hear our hearing, it would be nice if he or she had that already comfort level and would be willing to take a lead in that particular case. So I would look for someone in that genre. I would also look for someone who gave us pretty clear instructions up front on when they wanted their exhibits, when they should be turned in. To be honest with you, I didn't like someone with too far of a deadline. Maybe 3 or 4 days before would be, could be pretty much a hardship if you're dealing with different cases. I would like someone who in particular might say the day before. One arbitrator in particular didn't even want them until the day of. So as we start to navigate through this process, I start looking at different things like that. And one thing that would turn me off is, I think Jenny mentioned this earlier, a pre-hearing conference. That would be, it's not that I have a problem having one. I did have one arbitrator that wanted to have several. And that to me just took a lot of time frame. I felt like at that point we were a little bit more familiar how the process worked and, a little more comfortable with it. So I didn't really want to do a second meeting. I was okay with doing maybe a first one, and it lasted probably longer than I thought it should have. And a second one was definitely not something I wanted to do. So comfort level and experience are things that help when you're picking an arbitrator to hear your hearing virtually.
Thank you, Kim Kia. Jason, how about from your perspective as a management attorney?
Sure. I agree with what Kimkia mentioned as far as what you're looking for. I guess my perspective will be just a slightly different in that at this stage, and this is just me, kind of giving my thought on this, but how an arbitrator handles remote hearing based on our experiences with that particular arbitrator just becomes another thing on the list that we're looking at. And to me, it's always a sliding scale. So depending on, there may be other issues that are more important to the parties, the arbitrator's familiarity with the institutions, someone who kind of already understands some of the issues that might be more important, and maybe we'll just deal with some of those things that we might not like on the remote hearing front. So at this stage, I don't think that it's necessarily the primary driver of why we may or may not select an arbitrator, but it certainly fits into the equation. And then when we're looking at when we're looking at that portion of it, the remote capability of that arbitrator, I'm right with Kimkia as far as what we would like and what we don't like. I totally agree about the pre-hearing. Initially, I think that it made sense when this was sort of new to all of us, but at this point, you would expect if somebody offers that as an option, as a remote option, that they would kind of have an idea, or they could just provide you with some type of document that kind of lays out what you can expect, or maybe an instructional video, I don't know. But overall, again, it's more so just another factor from my perspective.
Thanks, Jason. And Mona, you're in a unique role because you're in a spot where parties may come to you with positive feedback, negative feedback, confused feedback based on their experiences with virtual hearings and the arbitrators who preside over them. What have you heard over the last 18 months from the parties you work with?
Yeah, and they do come to me with lots of feedback. So I would say, I would probably echo what Jason said, and also, to some extent what Kimkia said. I think the bottom line that I've seen is that an arbitrator's comfort level and skill with virtual hearings matters. It is a factor in arbitrator selection. It's not, like as Jason said, that it's not always like the deciding factor for sure. But I think like if you think about the cases that we see, the vast majority of them are pretty standard, like out of title cases or disciplinary cases, some kind of contract violation. And so for those types of cases that don't necessarily require like some deep institutional knowledge or experience with the parties, for those cases, if an arbitrator has expressed either discomfort with doing a virtual hearing, or just we still have some that just don't do them. They just don't want to do them at all, or they need a lot of tech support. They need sometimes the parties to step in and help them with the tech part of it. I have had instances, and I wouldn't say it's many, but I've certainly had instances where the parties have come to me and said, can we have a different arbitrator? So I think that, and or the arbitrator themselves may say that if it's going to be remote, I'm not going to be able to do it. And so I view it sort of as just another tool in the toolbox, right? I mean, everybody has, some arbitrators are really skillful at assisting the parties, towards like a mediated resolution. They play that role. Some write beautiful decisions, like whatever the case may be. This is just another skill that they have. And so it does have an effect, but I think as Jason said, on the rare occasions where there are cases where it requires a very specific touch, I think that the parties may be willing to either wait for the hearing to be held with a specific arbitrator or try to come to some other arrangement in terms of how the hearing is going to proceed. But, we certainly haven't had a lot of those. I mean, those sorts of cases tend to be kind of either very like large, complicated cases or politically charged cases. And those are rare, few and far between, right? But for most of the cases that we see, it's a factor, for sure.
Thank you, Manu. So it sounds like, Jason and Kimkia, listening to what you've said, you're fairly comfortable with virtual hearings at this point, but it sounded like for some cases, maybe even a lot of cases, but maybe not every case. And so let me ask you both, and Jason, I'll start with you. How do issues related to witnesses and witness testimony drive your comfort level when you're thinking about whether to proceed virtually or holding out for in person?
Sure, and my thought process on this has developed over the year, because initially I kind of thought that was going to be the issue, whether there's going to be issue if we put up a witness via Zoom, how they handle themselves, credibility calls, things like that. But again, it's just this experience factor, because at least in my experience, has proved that people have become used to this. And again, I think I mentioned this before, it's not just because people testify at arbitration every day. No, it's because we're all on Zoom all the time, family meetings, birthdays, things like that. People have become, sort of experts in how to do this. And I think the comfort level increases when, you have the time to meet with a witness before virtually, or in the same room if you are pulling out your computer and you're walking through things. So I feel like it's just like I hate to keep saying this is just another thing, but pre-pandemic there were issues about witness as well. Is this witness going to be comfortable giving testimony at this location, or is a union witness going to be okay with coming to the company's office to do the arbitration? Things like that. We've been dealing with that, and so this is just another thing that we deal with to get witnesses ready to present testimony. And so I really haven't ran into too many issues where after the arbitration, I said to myself that would have went way better with this particular witness if we would have been in the room together. So, that's kind of been my experience so far.
Thanks, Jason. Kimkia, how about you?
I think it's worked really well for me as a union attorney because our witnesses sometimes are extremely nervous, especially when they're walking into a room with the administration that might have taken some type of either disciplinary action against them or some adverse contract interpretation. And so I have found that for me and my experience that this gives my witnesses some comfort level. Either they're in the office with me and it's just the two of us, or they're even at home and I feel like they're just a little bit more assured of themselves when they testify. So I love it. I have had some fights, and just Jason and I talked about this when we were planning, where I have, felt that there was some intimidation that was going to be used when there was just some back and forth between me and the employer's advocate on whether that should be in person or virtual. And I felt like in some of those cases that the reason why the employer's attorneys in that particular scenario did not want to be virtual is because they did like that environment of kind of an intimidation that kind of puts your witness in a bad crossfire. Because a lot of times in my cases, it's just me and my member. It's not a line of people. It's just the two of us against the world. So I prefer it. And I feel like in the future, it would definitely be something that when I have a particularly vulnerable or delicate witness, that I would prefer it to be virtual and maybe they be somewhere where they're comfortable.
Can I just make a comment about the comfortable part?
Absolutely.
And I completely agree. I've actually noticed that the witnesses have been quite comfortable appearing. I can just see, I can tell in their presence that they are comfortable giving testimony through this platform. However, you have some people that fall to the other extreme of being comfortable. So it's important that we make sure that we remind witnesses that this is a formal proceeding and that they should present themselves that way. I say that because I had a witness show up in a bathrobe, which was, blew my mind. And then he lit a cigarette. And and that was something that caught me completely off guard. So, of course, after the witness testified, and we were in the sidebar well, I was in the sidebar with the two attorneys. The attorney was so apologetic, and so, and she thought she had, explained everything that she needed to. I guess she probably assumed that he would come dressed appropriately, but that's something that you probably need to point out. And as a result of that case, in my pre-hearing instructions, I now include a little statement about coming dressed appropriately.
The things you never thought you'd have to tell people, huh? Let me just pause for a moment. I know a couple of folks have had their hands up at various points. And Dan, I see you out there. If it's all right, if you could put what you've got either in the chat or the questions and answers, we'll get there. And if I see you keep that hand up for a while, I'll understand that you're insistent and I'll get to you at some point not too long from now. Turning back to some of the comfort level issue, the sense that I had, especially starting out and presiding over virtual hearings, was that parties were really relying on the relationships they'd built up, sometimes in deciding they did want to go forward virtually, and others deciding that maybe they didn't with the other person across the table. And so let me ask Kimkia and then Jason, how have you dealt with those situations, either where you've worked with someone before, and is that helpful in terms of, you've worked with them before in person, and is that helpful in working with them on video or virtually? And how, by contrast, have you felt when you've had to work with someone new as an adversary, and you're doing that for the first time on video?
I'm going to be honest, at this point, I don't think I've worked with anyone virtually that I have not had an in-person experience with. However, I can take a little note on that. There might have been someone I worked with and had a bad experience with. So I prefer to be virtual because we might not have had a good working relationship, or the parties might have some hostility. So the virtual takes that extra stress level out of being in a room where there are bad feelings. So I did prefer, again, I have a lot of things positive to say about virtual, so that's pretty much going to be my theme. But I definitely say that based on my experience, it's been with people I've worked with before, but based on the nature of the relationship, virtual might have given it a little bit of, made the experience a little bit better than it would have been if it had been in person.
Interesting. Thanks. Jason, how about from your end?
Same. I think that's just kind of how the chips fell over this year. It's either been with folks that I have dealt with before, or in one case, someone who other my colleagues have dealt with before, and I was able to talk about. So I've been fairly comfortable in as far as the relationship with the other side, because it is a different platform. There are avenues if someone wanted to engage in some type of crooked conduct. Maybe it's easier to do over Zoom, where you can't see where the person's hands are or what they're doing, or if they have a phone out, things like that. But and maybe I'm a little naive, but I do have general faith in our institution. We're all held to professional standards, and I always give people the benefit of the doubt until they prove otherwise. So I have a pretty good I have pretty good faith in that aspect of it. But again, we we don't know where we're going, and maybe down the line things start to change. People possibly get too comfortable. It's just like anything else in life. But right now, I feel pretty positive about interacting with opposing counsel on those issues.
That's good to hear. I think the continuing relationships that we deal with in our field are one of the things that, number one, make this work really a pleasure, and also helped us move online when we couldn't hold hearings in person. So, Mona, let me turn to you on the issue of witness testimony and some of the credibility issues that come into play. What have you seen in the hearings that have been held at OCB over the last year and a half or so?
Yeah, I think this is a great question, and I think it was one of the first concerns that was expressed by the parties when we first started shifting or encouraging them to shift to this virtual model, and I think the sense, and it was also expressed by some arbitrators as well, like, how am I going to be able to assess credibility if I'm not in the same room as the person or as a testifying witness? And I think the model that most people have been familiar with for years and years and years and years is that, and certainly what the parties expressed to us at the time was that, the neutral is in the room with the witness. They're looking at them. They can see their demeanor. They can see their behavior, their mannerisms, and through that interaction, they are able to arrive at some conclusion about the veracity of the testimony, right? I mean, that's not like a big shock. That's sort of how I think many people have been viewing this. But I think at OCB, what we really saw in that moment, like March of April of 2020, was an opportunity to encourage the parties to reassess that perspective and reorient themselves around this idea of credibility and how it should be assessed. So by that, I mean, there's been a lot of research coming out of academia around these issues of implicit bias or unconscious bias. There's been a lot of research coming out about trauma, for example, unresolved trauma, and how it lives in our bodies and shows up in the way we behave. Many people find it difficult to make eye contact. They find it difficult to sort of sit still. They fidget a lot. They essentially are engaging in certain behaviors that we might think means that they're not telling the truth, right? So we've been, encouraging the parties to kind of get a better understanding of that, right? And why is that relevant? Well, that's relevant because what that means, if you sort of follow that line of reasoning, is that being in the same room as the person then is not as critical when it comes to assessing credibility as we may have once thought. I mean, there's been study after study that has shown that we're not as good at telling if somebody's telling the truth or not when we look at them as we think we are, or at least as we'd like to think we are, right? I think sort of the comparison is that we're as good as flipping a coin, just all of us humans. So I think that if we're moving towards, I personally sort of see this as an opportunity to move towards like a more just way of assessing witness credibility that's actually grounded in evidence, in their testimony, in how their testimony matches up with prior statements they may have made, how whether there are other exhibits that, whether it's a video or corroborating testimony that supports it, right? So I think that shifting towards that model, I think, and understanding that context is means that being in the same room as somebody to assess credibility is really not quite as important as people may once have thought it is. And so to me, I don't think, and I think even as an agency, that's something we're encouraging our trial examiners to kind of use that perspective. And certainly, we've had those conversations with the parties as well and other neutrals.
Thanks, Mona. Jeannie, let me turn to you. As you've been presiding over hearings during the pandemic and doing that virtually, how have you addressed concerns about an arbitrator, but from the parties about credibility determinations over the last 18 months where this has come up?
Well, we've had this discussion quite a bit, and I know the Academy, we did an office hour, and that video is posted on our website about credibility. And just like Manu said, there's tons of studies out that that explain that we're not these human lie detectors that we think we are, and that in reality, the assessment of credibility does come from the evidence. I think some common sense based on the evaluator's experience is also important. And I wonder if that question about assessing credibility is more for the arbitrator, or is it a concern for the advocates? Because I'm wondering if maybe the advocates feel like they cannot assess a person's reactions when they're, examining or cross-examining a witness, and whether or not they, if the person is, tapping their foot on the floor, and that lets them know, aha, I'm going down the right line of questioning here, but I can't see that virtually. I wonder if that is truly the objection. I have not had it be presented to me as an objection as to why we cannot go forward in a hearing. I've just heard, and it seems that it's more, um, perhaps it is more of a concern than anything that has actually been supported by any type of true empirical evidence. I have yet to hear any report from an arbitrator that said, I was not able to tell whether or not this person was telling the truth through a virtual hearing. And I have a lot of conversations with arbitrators. So I think that perhaps it's time to move past that and, accept the reality that we are actually in a video, in a virtual hearing. I can see the witness much closer than I would ever see them in person. If I'm looking for their demeanor. But again, I think the bottom line is that it comes down to what their testimony is in line with the evidence that has been presented in the case.
I agree, Jeannie. That's a lot of good points in there. Let me ask Jason and Kimkia a question that I've wondered about, as everyone has had to slow down a bit on Zoom, because once you start talking over each other, nobody hears anything. So let me ask you, how has that affected your cross-examination, if it's a little tougher than it used to be to interrupt the witness?
Well, I just have to get used to it. I think from the verbal part of it, it was something that you just have to adjust to, because there is lag time, and then maybe the person who because you're having a conversation, at that point, and maybe the communication can freeze a little bit. That takes some getting used to. Again, I haven't experienced to the point where afterwards I said this would have went so much different if I was in person with them. But one thing I do like is, and I know we'll probably talk about exhibits, but on cross-examination, being able to really, really be in the driver's seat with the exhibits that the person is, looking at, instead of, having them fumble through binder number 8. Sir, that's binder number 7, go to number 8, and then they're thumbing through and it's upside down. You can share your screen, it's right there, and you can point to whatever you need to point through. So in that aspect, it's even more efficient. But it is a point well taken that it does take some getting used to, as far as how that conversation, the dynamics, if you like to interrupt people, how to do that over Zoom. So that's my experience with it.
That makes sense. Kimkia, how about you?
I agree with Jason. I don't feel like it has changed so much so that I would say, oh my God, I wish this person was in front of me and I could really go at them. I feel like I can see their face. Like Jeannie said, I can look right into their face and still be able to go through my cross-examination in an effective manner. So there's no negatives for me.
That's good to hear. Well, Jason mentioned exhibits, and so let's turn there briefly, and I'll invite each of you to comment one at a time. What's worked well, and what have been sources of frustration? And Kimkia, I'll turn that back to you.
I mentioned a little bit about that earlier. I think that when an arbitrator is very clear on when the exhibits are due, which is part of, I guess, the pre-hearing instructions, that helps a lot. It does force us to get prepared probably a little earlier than we normally would do. But I prefer having everyone have an exhibit book in front of them, including my witnesses. I don't particularly like the sharing of the screen. The reason I don't like it, I think it just slows the trajectory of the questioning. I might lose my thought, or you might lose yours. So if you have it, for me, if the witnesses have it and I can still look at, like Jason said, binder 8, tab 6, that has been more effective for me, maybe just because I'm used to doing it that way. I've done it that way for so long. But for me, I feel like if I have to look at your face and then read what's on the screen, or the witness has to stop and peer and look at it, I don't know what their screen looks like. They might have a huge setup, or they might just be looking on their phone or a laptop. To me, I would like using exhibits and making sure everyone has their books beforehand. And then we can just, if push comes to shove, we can share it, but I prefer it to be live binders.
Understandable approach. Jason, it sounded like you preferred the screen share more in your hearings. What's worked well and what not so much?
Well, I'm a little all over the place, Keith. So, I I do like the screen sharing, particularly on cross-examination. But I will admit it is a little easier, and maybe it is just because what I'm used to. If I'm looking at a exhibit book, even on my direct, it's more natural, and I will agree with that. But one thing that I will say, if you're going to share your screen to show exhibits, and I learned the hard way, is to ensure that your exhibits, that they share well. So if you're sharing some type of chart or Excel spreadsheet, being sure that you can actually read, that it's blown up enough. It may take a little bit of effort on your part to have to adjust the document so that it's presented in a way that's useful and helpful. You know, I've seen witnesses or arbitrators kind of have to lean in to kind of see what's on the screen. So I do think it does cause for a little bit of additional preparation if you want to go that route. If you're going to go the technology route, you have to go all the way there and make sure that it's going to come across well for everybody. So that'd be the one tidbit I'd add to exhibits. Other things is just making sure that you have labeled them properly, the naming conventions, making sure that makes sense if we're sharing it electronically. You know, all of those things that you don't necessarily have to think about when you just mail out an exhibit binder.
That makes sense. Mona, what have you seen in the cases at OCB?
Yeah, so I think I would echo, you know, some of what Jason and Kinkia said and I think overall in general, this idea about sort of advanced preparation on the advocate's part is always a great thing, I think, whether we're in person or virtual. So as an arbitrator, I love it. And I loved it when we were in person, when advocates would come in with very clearly organized exhibits. Everything was ready. I didn't have to sit there and watch them, you know, like fumble through like a mound of paper in front of them. Like, you know, when I didn't have to have those experiences, I was already in a good mood. So, and I think that having virtual hearings almost kind of forces that to happen. You don't have that luxury, if you want to call it that, of time and space to try to find the document that you want to present next. You know, I think that and it sounds like many arbitrators are doing this, and I certainly do this in, you know, in the cases that I hear, that I request all of the exhibits up front to be exchanged. Kim Kia, I hate to tell you this, but I do ask for a pre-hearing conference, a short one though, where, just very short one, where we can just, I let the parties ask any questions they may have, if anything's unclear in any of the exhibits, or if they didn't get a clean copy, or I find it useful if they inadvertently included something that shouldn't have been included. So it's sort of housekeeping type of things that we can take care of, you know, in like 15 or 20 minutes prior to the hearing instead of at the hearing. So I think that like all of these sorts of things I've found, and in terms of the arbitrators that I've spoken to, it seems to be pretty consistent that it makes for a smoother proceeding. I think that, you know, sharing screens, whether we're sharing screens or whether, you know, people have physical copies of it, I think that more often than not, people have been sharing their screen. And what I like is, because I have all of the exhibits, I share my screen. The advocate lets me know which exhibit to pull up. It's already open. I pull it up. I feel very in control and in charge, which is how I like to feel. And so I think that it's just been much smoother in that sense. And I think that there's still, you know, sometimes people are concerned, like, what if at the last minute I have something that I forgot to include? But there's still, you know, there's still latitude for that to take place. You know, you can still sort of pause and email the documents. It's usually not 20 additional documents. It's usually, you know, 1 or 2 additional documents that they want to include. So it's not that they're foreclosed from you know, from including additional things. Some of the issues that I've seen that have come up are the ones that would come up with in-person hearings. Invariably, there are practitioners or advocates who it's tough for them. That level of organization can be challenging. So I don't get the documents, you know, at the time that I requested. I need to follow up, things like that. But that was, you know, that's not a new and unusual, you know, challenge that we need to deal with. That's sort of always been there. So
I think that's right. Jeannie, how about in your experience in your cases? What's gone well and what not so much in dealing with exhibits?
So I think what the comments that have just been made, the key to them is that there should be flexibility, because different things work for different people, whether you have a hard copy set, you want to look at it electronically. I think that, and again, those pre-hearing instructions, what I typically ask the parties to do is to submit their documents to me within 2 days of the hearing. That just gives me time to organize them electronically, and it also gives me that window for uh, the situation where they're invariably not going to get them to me 2 days ahead, and I get them like a day right before. But 2 days, my assistant can kind of get everything together and ready for the hearing to go. The PDFing or using the Bates numbering on the exhibits, which is something I also suggest in those pre-hearing instructions. If the parties can use Bates numbers, and I'm finding that the parties do that pretty regularly now, and it makes it easy to reference during the hearing, as opposed to let's go to exhibit 11, let's just go directly to Bates number, whatever it might be, and we can immediately get there. I ask the parties at the outset if they want me to share my screen, if they're comfortable sharing. So again, that's the flexibility component. And then the only other cautionary comment that I would make is that with regard to going through the exhibits during the hearing, is that the advocates should be careful to allow the arbitrator time to get to the page. And that's something I think you see that physically when you're in person, you see people flipping through, but virtually you can't really tell if they're at the page or not. So that's something I have to often ask the parties to wait. They start immediately asking questions once they get to the page, but I haven't actually gotten there yet, whether I'm looking at it on the screen or whether I have it physically in front of me. But overall, listen, I have had parties to use very sophisticated exhibits, and they were quite comfortable with displaying those exhibits themselves. I mean, it has not been a problem. I would say that has been, I mean, even with the video, they're very comfortable with sharing video. And so the exhibit sharing and the use of the exhibits, even their witnesses, they've done a really good job of preparing their witnesses on accessing the appropriate exhibit. At the right time. So I'd say that's been a positive. I don't really have any negatives with regard to exhibits, except get them to me within 2 days.
Well, that brings me to my next question. For almost universally, I've heard in the course of our discussion today a lot of positives about virtual hearings. So let me ask each of you if there are any negatives you've run across, things that don't work as well or are less beneficial to the process than an in-person hearing would be. And one that jumps to mind for me is sort of the relationships that we talked about a bit earlier. And Monu, if you don't mind, let me turn to you a bit and see what your experience has been, since you deal with a lot of parties and a lot of repeat players at OCB in New York.
Yeah, so I think there are probably 2 areas that jump to mind for me in terms of some negatives. One is, sort of simple, and I think it's probably an issue for everyone, is that when there are tech issues, it can be challenging, right? Whatever those tech issues might be. And again, I don't think that they make hearing the case impossible. It just requires you to pivot and possibly improvise a little bit, problem solve a little bit, and you can get back on track. But I think that from what I've seen, that's kind of been the biggest biggest immediate obstacle when it comes to virtual hearings, or irritant, in terms of the process. But the other thing I think is, what you mentioned, Keith, like, I think, when I was an advocate, and certainly what I observe as an administrator, as an arbitrator and mediator in my role now, is these relationships. I mean, I can feel grumpy about the advocates wandering off during a break and then not coming back in the 15 minutes that I've laid out for them. But the reality is that often they're busy taking care of business. And I used to do that too, right? Is that you're in the same room together and we're, for a hearing on a particular case, but there may be like 5 other issues that you're working with this person on, and sharing that space and being able to have a conversation with them about it. I think it not only lets you get certain things off your plate sooner rather than later, but it creates, it's all like little drops in the bucket in terms of creating a collaborative relationship with opposing counsel, which I think particularly in labor relations, right? Like very specifically for the work that we do is so critical, because I think that we all play our roles, but all of our roles are in support of a larger process. And I think that for people who have been doing this for a while, there is like a very deep understanding and appreciation of how important these relationships are to the success of that process for everyone involved. So I don't think, we have had, we've done some hiring at OCB, within this period where we've onboarded people virtually, and there are certain practices we have in our agency, like we have staff meetings, et cetera, that kind of have helped to try to develop, a relationship with people. And I think that even over Zoom, as people have become more comfortable with each other, you get to see a little bit more of their personalities, even in hearings. And so that has helped too. But that I think is probably has been the biggest sort of larger issue, right? Relative to the tech issues that I see.
Thanks, Monu. Jeannie, any negatives that you've run into with virtual hearings overall?
Would it be bad if I said no?
Oh, that's all right.
I was actually thinking, I was struggling to think about that as Mona was speaking. And because even with the sort of intermingling that parties do, I've actually had parties say, "Oh, can we stay on?" And you jump out like after the hearing ended, and they continue on and have a conversation about whatever, some other case they're working on. I just make someone the co-host and I jump off, So um, so even with that, that's been workable. I find that I have seen more people through this platform than I have seen over the years. We may have a phone conversation, a conference call, but now we're doing more video, and you can't, once you see someone, you can't see more of their personality. There is more of a personable interaction than just a conference call conversation. And that has even been the case with the parties when we're on break. We have some of those same discussions. We're not standing around the vending machine having them, but we're still having those same types of conversations that we all find very valuable when we are able to get together. So
Nothing wrong with having a uniformly good experience, especially something, with the format you've had to use for the last 18 months or so. Kim-Kia, how about you?
I want to piggyback a little bit off of what Mona says. I think one of the points that she made was some of the interactions that happen away from the hearing. And I'm going to say a trade secret. I hope I'm not betraying other union advocates out here by saying it, but sometimes we go to arbitration and we really need our client to see the arbitrator. We need them to see the process because they might not have listened to us up until that process, up until that time. And everybody, sometimes there are people that just need their day in court, as we say. But when they see the process and they see what's going together and that there's a case that's coming against maybe them, that maybe at that time they're a little bit more susceptible to what you're trying to advise them on. So if an arbitrator or the neutral is, doing a mediation kind of process where he or she takes that person in the hallway along with their advocate and kind of give an assessment or talk to them, that has a lot of value. I mean, it's actually very important in how sometimes we pick arbitrators for certain cases, because we know they offer that kind of mediation arbitration process. So I could say that one of the negatives would be is that when we go virtual, we're pretty much in the hearing. It's not that little kind of milling around, kind of deciding how the case is going to look, and the arbitrators flip through the binder and says, "Can you talk to me in the hallway?" You kind of lose some of that impact. Also, I'll just say something a little bit more practical: screen fatigue. I mean, we look at screens all day. We look at TV, we're looking at our iPad, we have our phone going, and sometime in the middle of a hearing, I feel like I'm used to doing two things at the same time. When a screen is on, I consider, flipping through my phone. So making sure I can keep my attention focused, that I'm actually active and engaged in this particular hearing and not just looking at a TV screen like I am at home. So I just think that's part of that would be a negative. Like, we're just tired of everything being on a screen. So other than that, I'm with Jeannie. I think, there's way more good than there is a negative. I look forward to keeping this part of our, part of our process, but that would be the two things I would say that are definitely cons.
Thanks, Kim Kia. Jason?
I don't have anything different. The one thing I was going to add, Kim Kia hit right at the end there with the you hear the phrase Zoom fatigue, and I won't rehash that out. I can only hope that as we have to rely on the virtual world less, that will be less of an issue if this is one of the only things that we're not forced to do, but that we're doing on a screen. The human element, a lot of our discussion have been about mechanics of the hearing, credibility, but as everyone has said, that human element, especially in labor relations, is key to some sort of tangent issues that come along with these cases. And I don't think that there's a replacement for human interaction. I'm sure there's like Zoom dating things out there, but at some point you're going to want to meet the person, because you can't deny that human interaction. And I think that it does solve some of the issues that we deal with. I enjoy, and my clients do, going to a new place, or maybe we're having a arbitration at a union hall we've never been to, and kind of learning, and especially when the parties are cordial. Those things are valuable to we're repeat players. We deal with each other all the time, and those relationships are important. So I think you lose a little bit of that if we're exclusively relying on remote means to conduct this type of business. But again, I don't see it outweighing what the benefits are.
Thanks, Jason. So let me turn our focus to the future, and we'll put on our rose-colored glasses and be optimistic, and think of a time when the pandemic and the health concerns that it raises aren't hopefully at least as much of a driving factor in the decision to go forward with a hearing on video versus in person. So I want to ask each of you how you see virtual hearings being utilized in the longer term. I'll give you an example from my own practice. I have a case where it's going to be measured in years or decades before we're done. Counsel is all close to me geographically, and the witnesses are not. And so in that case, what we're planning to do is, when we can gather safely, I'll be in the same physical spot with lawyers for both parties, but the witnesses will be on video, because there's no reason to pay for all of us to travel out to where they may be if we can just have them appear and everyone agrees to it. So that's an example of a use that I know I'm going to be making of virtual hearings going forward. But Jeannie, let me start with you. how do you see these hearings on video being used in the longer term?
Well, I think that, as I mentioned earlier, it should be a consideration, if, the question should be asked, is this a case that's suitable for a virtual hearing? Um, I don't think that 100% virtual is what anybody is interested in. I think though, but to the extent that we can have more of a balanced approach to the amount of travel we all have to do, because it's not just the arbitrators, the advocates have to travel to their clients oftentimes as well. If we can create more of a balance with that, I think it will help us all be just that much more productive. And so in trying to determine what that balance is, the sort of gateway question would be to ask, is this a case that would be appropriate? And if not, it's not, and you proceed with the scheduling. So that's how I plan to approach it anyway.
That makes good sense. Mona, how about from your perspective?
I mean, they're here to stay, and I think that there's really no, not just no way around that, but there's no reason for us to be finding a way around it. I think that based on the experience that has been shared from people on this panel, and also from the conversations that I've had with the parties, I think pandemic or no pandemic, this has been shown to be a really effective way of dealing with many cases. I absolutely agree with everything Jeannie said. There may be reasons that certain cases may be better suited for in-person, but what I think we're going to see is actually, as the comfort level grows on the parts of practitioners and unions and agencies, I wouldn't be surprised to see actually very complex cases being done virtually. And I think in other practice areas, right? I have friends who do immigration work. I have friends who are sort of in like an international business type of setting. They've been doing virtual hearings for years and years and years. So almost all their cases, and these are incredibly complicated cases, are done virtually. And so I think that we're going to, speaking specifically from OCB's perspective, this is going to be a regular offering for us to our parties. And I'm sure that many of our arbitrators who are on our panel are going to be doing the same. And I think it's just going to be a matter of sort of assessing the case. And if there is a very compelling reason for it to be in person, then it may be in person, or vice versa. I think it's just going to depend. But I think it's definitely here for the long run.
Thanks, Mona. Jason, how about you?
Agreed. I don't think that it's going anywhere. I think that has been stated that it just becomes a tool. It's just another avenue for us to consider. We're all in the business of resolving things, and it's just another way to do that. I think that one thing, and I think he has sort of started to mention our clients. I think it is incumbent upon particularly the attorneys who are on the front line of this to sort of speak, advocate to their own clients about outside of the obvious, the cost, but why this works and what the pros. These same conversations that we're having here, we should be having with our clients so that they could sort of see the light, so to speak. So I think that that's going to be something that will also drive this, but as a whole, I think this is something that we're going to be continuing to use.
Thanks, Jason. Kim-Kia, how about you?
I don't have anything additional to add. I agree with everybody's perspective. I think it's definitely in the future. I think it's definitely going to be an option that we're going to always want to have. And as Jason said, when it comes to our clients and our organizations, we're going to be able to see a financial savings, we believe, because we don't have to worry about time and travel and coordinating a whole bunch of witnesses who might be stretched out all over. It's just going to be something that works. And I think it does work.
Thank you, Kim-Kia. So we have gone about 90 minutes, and I can tell you we could go for another 90 easily. But you all have other things to do with your afternoons or late mornings, depending where you're joining us from. And so I thank the 175 of you that have stuck with us throughout. And we've been able to address a number of the questions that have come up in the chat, in the Q&A, and I've particularly enjoyed seeing our audience answer each other's questions as we've gone through the course of the presentation. I'm going to put a number of files in the chat briefly, some additional materials from Alra. Let me put that there for you. And those will be posted along with the materials that, well, that's not working. We'll make sure those are posted with the materials that Jeannie gave us earlier when this goes up on the ABA website. Let me turn to each of our panelists for any closing thoughts or anything that you wanted to share before we wrap up and send folks on their way to the rest of the day. All right. Well, hearing none, thank you, everyone. Thank you to Jeannie, to Kimkia, to Monu, to Jason, to Brad and the ABA for keeping this running the whole time. It's been a pleasure being with you all this afternoon. So thank you, everyone. Be well and stay healthy out there.
Stay safe.
Take care, everybody.
Bye.